Hey everyone, Rob Ryder. It's November 27th, 2012. And I'm going to get on here shortly to an idea for a petition to try maybe into a court of equity. But first, just a few interesting things that I found last week or so. Here's a organizational structure of the state of Michigan. And you got the citizens of Michigan at the top. And the one of interest is the judicial branch. It only shows a Supreme Court and a Court of Appeals. No circuit court, no probate court, no district court, no family court. Those courts aren't part of the state of Michigan, apparently. So, something to ponder. I don't know what to do with it, but again, if this is the organizational chart for the state of Michigan, well, we only have the Supreme Court and the Court of Appeals. I believe there's 4 courts of appeal, and it kind of makes sense. They split the state into 4 pieces. And this goes back to territorial times, just before the state of Michigan became a state in 1836, I believe it was. There were 4 districts or circuits for the 4 territorial judges, and each of them had a district. And in that district, they wrote a circuit. So there were circuit court judges. So, and I think that's what now became the Court of Appeals. At that time, these guys who sat in these circuit courts would all get together in Detroit, and they would form the Supreme Court a couple times a year. Same guys. They would just sit in their separate districts most of the year, get together. Any of the cases that had been appealed from their particular district would end up in the Supreme Court, and they'd get a quorum to agree who was right. Did they overturn the ruling, or was the ruling good? So, this is what the state of, and this is upper lower case, state of Michigan, I believe that to be the de jure state, what it looks like. So, okay, and then a couple other interesting things. Again, if you're ever looking for the bonds for civil cases, recording of bonds in civil cases, that it shall be the duty of the county clerk in all cases where bonds or other obligations are filed in any civil case, either on the law or chancery side of the court, to record such bond or other obligations in a book in the office of such clerk to be kept for such purposes. So, who's the county clerk? Well, again, I believe that to be here in Michigan, she's also this clerk of the court of record, the circuit court, county clerk, clerk of the county of. But as you can see, they have 2 different sides in their office. They have the law side and the chancery. Well, if one side's law and the other side's chancery, chancery is the equity side of the court. It's really where we're trying to get to, is a court of equity. And this was interesting. The appointment of the chief judge for each county. The Supreme Court shall appoint a chief judge for each county. The chief judge of a county shall then appoint a chief judge of the circuit court in that county, a chief judge of the probate court in that county, and a chief judge of the district court in that county. But the chief judge of the county has been appointed by the Supreme Court. So we're looking for this is the guy we want. This is the chief judge. He would be over the office of the recorder. Normally the chief judge is the way the definition reads. And whatever's in his office and those files and those records is what the law is going to say. And we're trying to get them to say we're the owner. Or we have ownership rights. People got a problem with the word owner. Get over it. Right to use, right to enjoy, right to dispose of. The Supreme Court shall appoint chief judge for each county. Look to see who's been appointed by the Supreme Court. You have found the chief judge. And that's who you really want to get your petition to. He would be, in my opinion, sitting there as the chancellor. So if we're trying to do a petition, then here's my idea. Now, this is kind of what a petition out of probate looks like in Michigan. Right? So there's really nothing fancy to it. I would think someplace you're going to want to list the respondent and the petitioner and the respondent. But this is kind of reading where you're just putting it in. Interested persons, addresses, so these are the other interested persons. So who's the respondents, right? So I've not done this as a form to use. This is really the body of information to use in whatever you would decide you want your petition to look at. But it's a petition for equitable relief. So comes now petitioner, whose real full name is, and that is your last, first, middle, real full name, go Google it. Says it's your surname coupled with your first and second. Well, surname would be your last, coupled with a comma, first and second. For equitable relief in a matter of unjust claims of respondents and others unknown to me concerning ownership rights, title, and interest in certain real and personal property of the petitioner. Now, I know there's a little Latin phrase or something you can use in the respondent box if you don't know who all the respondents are, right? The unknown respondents. I just don't remember what it is. Equity looks to substance, not form. So all these highlighted ones are basically maxims of equity. So equity looks to substance, not form. Petitioner is led to believe a stamp tax may be due for this petition to be seen by a competent tribunal and ask the clerk of courts to affix any revenue stamps required by a procedure if its substance is necessary. This goes all the way back to the Tax Act in the 1700s, where they put a tax on paper, and any legal document had to have the stamp on it, or it could not be seen in a court of law or equity. President Lincoln brought this back in 1862. It cost a nickel. If you didn't put the stamp on, your document could not be seen in a court of law or equity. People say that went away. I don't know. I think it showed up again in 1919. It talks about it being in Chapter 34 of the Internal Revenue Code, which is now apparently Title 26, USC. Looks, when you read that, like it's gone away, but, you know, it's got a hell of a lot of caveats on that page. So I don't know that it's gone away. Bobby out in Arizona was looking at the duties of a post office employee, or maybe even the post office postmaster. The job description, and in there it talks about handling postage and revenue stamps. And again, a revenue stamp is not a postage stamp, it's a revenue stamp. And really, I think that a lot of these all capital letter organizations we walk into, they're all federal corporations, right? Well, how is it you can go in Michigan to the Register of Deeds, if it's a county office, and fill out a frickin' passport application? They shouldn't have anything to do with federal if it's a state, county office. Yet there they are. That's what they do. And you also go there with to the Freedom of Information, which is another federal program, to the county, right? How come the county doesn't have their own Freedom of Information? It's a federal program. A lot of those offices, I think, are really, if anything, they're part of the federal corporation. They're certainly not part of the state government, because the people holding the office haven't taken the oath prescribed in the Constitution. So they're not holding a state public office. Anyways, back to this. Equity. So equity looks to substance, not form. So I put this in here mainly for you to say, okay, make sure you ask them, hey, is there any stamp tax or any duty required on this document for it to be seen by a competent tribunal? Ask the frickin' clerk. Equity will not suffer wrong without a remedy. Petitioner believes respondent or their agents learned in the law, officers of corporations bound by solemn oath, may have acted in bad faith. Well, that would be a wrong. And so equity won't stand for it. They won't suffer wrong. There has to be a remedy. Equity will not permit a statute to be used as an instrument of fraud. Petitioner believes certain instruments have not been lawfully executed as part of a scheme to control the rights, title, and interest of the petitioner's land, real and personal property, described on an instrument titled warranty deed, deposited in the office of the Register of Deeds in the county of, book, page, date, as well as deed of trust deposited in the office of the Register of Deeds, the county of, date, as may be required by certain statutes to secure petitioner's claim of right. Certified copies of both are included with this petition. Maybe I should have said of certified copies of the warranty deed and deed of trust. And again, yours may be called a mortgage. It may be called a security deed. It may be called not a warranty deed. It may be called a grant deed. Whatever they're called, and maybe it's not a book and a page. Maybe it's a file number. Whatever is on the paperwork. And from those two documents is where you're going to get most of the respondents you're looking for. I mean, there should be the lender on there, the title company on there, escrow company. List them all as respondents. Anybody that has any interest at all in the action is supposed to be contacted. So you may have to put all of them on a separate piece of paper. So you say see attached sheet of respondents, possible respondents, and then whatever the caveat is for the ones that you forgot. Equity regards as done that which ought to be done. Third parties involved as agents have not executed their fiduciary duties as part of the closing of the bona fide sales contract, known as the warranty deed, to ensure it was properly recorded, transferring good title into the hands of petitioner, resulting in a form of joint tenancy between the petitioner and third parties of unknown identity. Petitioner requests the discretion of the Court of Equity to compel the immediate specific performance and lawful execution of the sales contract known as the warranty deed, resulting in the good title deed to the land being placed in the petitioner's hands. Right? We want the title deed in our hand. That's pretty self-explanatory. So equity will not assist a volunteer. And what's a volunteer? Well, the volunteer is somebody who gets a gift. The warranty deed indicates that the grantor granted and conveyed the land and real property described on its face. This isn't written too well, obviously. The warranty deed indicates the grantor granted and conveyed the land and real property described on its face, and it should be here, and said grantor's recorded acknowledgement of receiving good and valuable consideration and satisfaction of the sales contract is evidenced by the included warranty deed. Basically, the certified copy of the warranty deed that you're going to get from the Register of Deeds is going to show that the grantor says he's been paid. He acknowledged it under the seal of a notary. So he's already been paid, but they haven't completed the sales contract. Right? And so when you think about it, both you and him were acting through some agents who were learned in the law, and what they haven't done is completed the contract. They're not operating in good faith. Petitioner was compelled by the deceit of those learned in the law that a loan was required between this petitioner and a lender evidenced on the included deed of trust as part of the land purchase by warranty deed, upon which the lender claims to be loaning the petitioner the lender's money. Petitioner is led to believe there is no recorded bona fide lien for a loan of money. Said deed of trust has not been acknowledged by the lender or trustee of record, resulting in an unexecuted bilateral agreement with which the lender now claims an equitable mortgage over the real and personal property of the petitioner's landed estate. Your all capital letter name is the name of a landed estate. You gave them control by putting it down on a piece of paper and giving them the damn piece of paper. It is not the petitioner's intention for this to be a gift or an unexecuted use held in trust under control of the lender as a binding unilateral contract. Therefore, I wish to revoke the deed of trust and ask for injunctive relief by court order to have my securities, their conversion and gain, returned to the use of the petitioner. I want my property back. He who seeks equity must do equity. Petitioner wishing to ensure equity is given to and by all parties of interest openly admits not being learned in fictional forms of law. Petitioner fully comprehends and stands under the laws of his Redeemer, the Lord Jesus Christ, asks that if necessary to ensure the transaction made in good faith is properly executed, counsel learned in the law be appointed to represent the petitioner. Have them appoint counsel. They can do it. The chancellor can do whatever he wants to do. Within reason. Within his conscience. And we're calling his conscience to the table. As other instruments of indebtedness appear to be claimed against the land, real and personal property of this petitioner, there is a possibility these instruments are done in bad faith. Petitioner asks that all records, books, and accounts with full accounting as they apply to petitioner's landed estate, again, your all capital letter name, be subpoenaed as evidence to determine and establish the petitioner's rights, title, and interest in them. All right, so I'm going for it all here, right? Yeah, we taken care of the damn house. Now let's go get our other property. What else is out there that somebody believes that there's an indebtedness against us, right? Property taxes? Yes. Our estates are being held in trust away from us, so we can't get access to them. Well, we're going to have all those records and accounts brought in. Petitioner believing it is his duty to the King of Kings to point out transgressions of his law, has brought this petition forward into the court of equity. As the court has now been made aware, I leave it in the hands of the competent tribunal, the keeper of his conscience, to see that swift justice is done in his name. And I threw this in because I could. Romans chapter 12. Be of the same mind toward one another. Do not set your mind on high things, but associate with the humble. Do not be wise in your opinion. Repay no evil for evil. Have regard of good things in the sight of all men. It is possible, as much depends on you, live peaceably with all men. There you go. So, right, we're not repaying evil with evil. We're just pointing out transgressions. I'm not going to do any more than bring it to the judge's attention. He's the one who's supposed to hand down the justice. But if I haven't pointed it out, well then, nobody knows that it exists. And then on a petition, like on this one here, I declare under penalty of perjury, right? That's all you really need to put. You don't need to go in front of a notary. You don't need to do anything except fill in the blanks. So I declare under penalty of perjury that this petition has been examined by me and its contents are true to the best of my information, knowledge, and belief. Nothing wrong with that. So you can put the number here, write out the month, put the year, your signature, but I would put your printed real full name, which again is your last, comma, first and middle. Your address is only, when you look at these things, the only thing on the address line is the road number and name. Then it has a separate line for city, state, zip. And you can see how it has state written out. So I would put, in this case, state, Michigan, the whole thing. And a phone number. All right, so there's a petition. Now the question is, who do you take it to? Well, you're trying to get it to the chief judge. But I think that you could take this to whoever the clerk of the court of record is, to their office. Right? And tell them you're trying to put a petition into a court of equity and trying to get it to the chief judge. And if they hem and haw, say, that's fine, I'm leaving this copy with you, you've been served, and I'll be sending a copy to the judge of second instance. And the judge of second instance is the archbishop at the metropolitan, at the archdiocese of where you are. Interesting, all of Michigan, as far as the church is concerned, is called the province of Detroit. It's all provinces. Those are all kingdoms within the larger kingdom of the King of Kings. And at a local level, the judge of first instance is supposed to be the bishop, but he delegates, apparently, because he can, his powers to certain others, to certain others. So he's over the court of chancery, although they say we don't have a court of chancery anymore. It's funny. You find chancery used all over the Michigan compiled laws, even though it doesn't exist. It's still there because it does exist. And he's the chief judge. But he has delegated his authority in certain jurisdictions of equity to certain different courts. And it appears that the probate judge is supposed to be over trust and estates. But, we're just going to give it to him, and in my opinion, make him take it to the right person or leave it with him. And if you need to, send a copy to the archdiocese and say, look, I'm trying to get relief, right? And they won't take my petition. But leave a copy with the clerk or whomever it is you finally get to and you said you had enough. Fine, you've been served. Make sure the chief judge gets it. Because I'll be letting the archdiocese know that I've dropped one off. So I'm guessing that because you're supposed to submit your petition to the chancellor, that who this is really going to is the chief judge. And when you figure out who it is, you would be sending it to his office. You may even just put it in except you need to ask if it needs to have a tax stamp. If they say it doesn't, say, well, fine, then take this to the secretary of the chief judge. Whoever you end up talking to, whatever clerk it is, fine, take this to the secretary of the chief judge, because that's her job, is to take care of the chief judge's correspondence. Make sure you put your address and phone number on it so we can get a hold of you. We'll see what happens. But, in my opinion, this has covered the points that need to be covered using equity, which it has about 14 principles, the maxims of equity. And so that's the principle, and then what are the facts that support it? And so these are the ones I came up with. You may come up with others. Now, as far as if I got deed of trust, uppercase, lowercase, hell, I don't know. It's just as I type. Sometimes I put them in upper, sometimes I put them in lower. I don't know. And make sure that you put a certified copy of your deed of trust, or whatever it's called, warranty deed, whatever it's called, attached to this petition as evidence. Go down to the courthouse and start asking some questions, and don't come back with the paper. And then we'll see what happens. Okay, that's all I had for you today. We'll see what happens. Good luck, guys. Take care.